Hi, my name is Joe Shannon. I have a law firm called Shannon Law Group, and we handle litigation cases. What I want to talk to you today is about birth injury cases. These are very sensitive cases, and the cases that we normally deal with in a birth injury case is cases involving cerebral palsy. That is when a youngster is struck with a birth injury that causes cerebral palsy. So in this video, I want to take you through the step-by-step process in dealing with a medical negligence case. Now, a medical negligence case in Illinois is much more difficult than a regular negligence case. And I'll tell you why. The Illinois legislature has required that every medical negligence case, that's a case against any medical care provider, whether they be a medical doctor, a hospital, any sort of nurse, a chiropractor, any medical provider, any of those types of cases first requires the review of all the medical records by a physician who understands exactly what that field is, and that physician or medical provider has to provide an affidavit to the attorney saying, number one, that there was actual negligence involved in the care and treatment, and secondly, that negligence caused the injury or death to the person involved. So this is a really big hurdle to go over in order to file a medical negligence case. As such, despite what you may hear in the media or in other news reports, the filing of a medical negligence case in Illinois is rare, and the recovery in a medical negligence case is also rare. That's because it's required that you have the medical negligence certificate or affidavit from a medical care provider first, and that these cases are very difficult and complex because medical care providers oftentimes don't believe that they were negligent in the cause of an injury, and that's part of the system. Our justice system deals with only evidence and proof of negligence, not allegations of proof. So you can't go to the courthouse with just allegations. You must have proof. You must have evidence that the actual negligence caused the injury. And that's why it's rare that folks will win this type of case without the proper proof. So I want to walk you through that step by step. The first step in a medical negligence case is the consultation with the lawyer. So that involves some research. The first step is to research who would be a very good lawyer for you to represent you and your family in a medical negligence case. Say, for example, a case involving a birth injury where the little one has cerebral palsy. In that type of case, you want to look and see what types of firms deal with those. Now, we've handled those types of cases along with other firms, and they usually take a long time to get resolved. They take a long time to review, and they take extensive research, investigation. It takes a lot of time and expertise to handle these types of cases. So the first thing is you would call that lawyer and start a consultation. So in a consultation, what happens is the lawyer and the family sit down and talk about the care and treatment to date of the child. What we typically will do is try and find out the timing of the injury, what type of care and treatment was provided during the prepartum stage, as well as the postpartum stage, as well as the delivery. The next step is to get all of the medical records and bills. But before you can do that, when you're in the consultation with the lawyer, if you like the lawyer and have trust in the lawyer, you'll sign a retention agreement. In Illinois, it's required that in order for there to be an attorney-client relationship, there must be a written agreement setting forth what exactly the lawyer is going to do for you. Also setting forth what the fees are going to be. So the first conversation that you have with the lawyer should involve money. What the percentage is going to be for the fee. So typically in these types of cases, They're handled on what they call a contingency fee agreement basis. Typically in these cases, the lawyer will recover 1/3 of whatever the client recovers, plus there'll be a return of any costs that are advanced. Let me break that down for you. So typically in Illinois, the lawyers will advance the costs of filing a lawsuit, as well as for the expert fees, deposition fees, any other type of out-of-pocket costs for the client. And at the end of the case, if there's a win, then the client will repay through the proceeds the attorney for those costs. So the attorney will recover a contingency fee, which is typically 1/3 of the total recovery, plus he or she will get back their costs. That's the first stage, the consultation. The second part of the case involves getting all of the medical records. So in your consultation, you'll sign a bunch of forms. One of them will be the equivalent of a HIPAA, which is basically an allowance for the attorneys to get all of the medical records from the medical care providers that were caring for the child and the mom before the pregnancy, during the pregnancy, labor and delivery, and postpartum. Once all those medical records are obtained, the third phase is that, as we talked about before, an independent expert will review all the medical records and make a determination whether there was any negligence on behalf of the medical care provider. Now, everybody makes mistakes. Medical care providers also make mistakes. That doesn't say they're not good people. All of these people that we've been involved in these cases, they're good people. But sometimes mistakes are made, and that's what the court system is for. All of us pay enormous taxes to provide for our court system in America. The court system is basically a dispute resolution system for us, so that we can have these cases decided civilly with a independent judge involved, with each side represented by counsel, and each party having the opportunity to get evidence from the other. So the third phase after let's go back here. After the expert reviews all of the medical records, if that expert, and only if that expert, determines that there's been negligence involved, and that negligence was a proximate cause of the child's injury, is the next phase, which is filing a lawsuit. Now, that lawsuit will be filed in the proper venue. That means it'll be brought in the courthouse where the cause of action occurred, or where the defendant resides, or if it's a corporation, where the corporation does business. So, bringing a cause of action or a complaint in the proper venue is the next step. Now that usually will start a 2 or 3 year, or maybe even 4-year process until dispute resolution. Now this is a long time, I understand that, but in these COVID times, may even be more prolonged because of the backlog of cases. But these are complex cases. These aren't cases that involve who ran a red light, who failed to stop at a stop sign, that type of thing. It usually involves complex issues like who is in charge of the care, what is the standard of care. There can be in these cases upwards of 10 experts for each party. So there's usually a lot of travel, there's usually a lot of logistics and get this thing in order, and a lot of time for preparation to get to the point where you're ready for a trial. So that's the next step, filing the case. Now, what does filing a case do for you? Well, it gives you subpoena power so that you can subpoena all the records that you don't have already. It also allows the party to take depositions. Now, our clients will be deposed. Usually the parents are deposed and any relatives that are relevant. There'll also be depositions of the medical care personnel and any other providers that were involved in the care. The next step after the parties are deposed is the depositions of the experts. Now, there'll be experts for both sides. There'll be the experts for the family, which will typically involve the same discipline as the defendant. So say, for example, there was an OBGYN that was the defendant. The expert for the plaintiff would have to be OBGYN as well. There's also experts on damages. Say, for example, that there's been interpretations of MRIs or CT scans, and those folks will take a look at the case to make sure they know what the opinions are and will provide opinions. So there'll be experts on financial, what financial distress the family is in due to the negligence. So say for a case involving a child with severe cerebral palsy. We had a case like this in the last 10 years in which we had about 9 or 10 experts. One of them was an economist, and the economist took a look at what it would cost for the care and treatment of this child for the rest of that child's life expectancy. Also, a life care planner, a doctor who would make a decision as to what medicines, what type of medical care would be needed in the future. Because typically, a lot of these children will outlive their parents. So there'll be issues with respect to what kind of costs will be incurred that were being met by the parents or the family. So these are very serious issues that need to be addressed by experts. And there's folks that are able to come up with specific dollar figures for the care and treatment of the child for the rest of their life. So that's the next step, all of the discovery of the parties and then the experts. The next step is getting ready for a jury trial. Now, a jury trial in Illinois involves typically 12 jurors as well as alternates. And this will typically take place years after filing. Now, typically there will be a mediation or two before this to see if the parties can come together and resolve the case. And we've made the assumption that those mediations have not happened or did happen but did not come to resolution, so we get ready for trial. At this point, the decision as to who is going to win the case or lose the case becomes in the hands of the judge and the jury. At this point, the jury will hear all of the evidence, will hear the evidence of both the parties and the experts, the economists, the life care planners. They'll also hear from the defense, the doctors and physicians that were involved, the nurses, from their experts, and they'll hear all of that evidence. At the close of the evidence, the jury will be read what they call jury instructions. And the jury will be instructed what the law is in Illinois, what the standard of care is in Illinois, and what the measure of damages is in Illinois. Here's what some of those instructions are. If you find that the defendant breached the standard of care and that breach was a proximate cause of the injury or death to the child or to the family, you must find for the plaintiff. Alternatively, the jury is instructed, if you find from the evidence that there was no breach of the standard of care, you must find for the defendant or defendants. Alternatively, if you find that there was a breach of the standard of care, but it was not a proximate cause of the damage to the child, then your verdict is for the defendant. So the jury has decisions to make as to who is at fault and whether that fault caused the damages involved. It's complex, it's not easy, but it's also something that is very important to our community, that folks show up for jury duty and listen to all this evidence and make an independent decision for both of the parties. After the jury has made those deliberations and come to a unanimous verdict, then they will deliver that verdict to the judge who reads it in open court. The verdict is read, and then if the plaintiff wins, then there's an order drawn up saying that there's been a judgment for the plaintiff in X amount of dollars. If it's found for the defendant, then there'll be a judgment for the defendant. Now, each side has a certain amount of time to appeal, and it goes to the appellate court if they appeal it. otherwise, um, the plaintiff, if he or she wins, um, typically the defense will pay the judgment, and it'll be collected, and then there's a decision to be made, which is the next step, which is disbursement of the money. Now, typically, when there is a child involved, the court is also involved to make sure that the child is taken care of. So, in a typical case where the parents are the guardian of the child, then they will listen to what the parents would like to do with the money, but they want to make sure that the child is taken care of for the rest of their life. So there's an order entered with respect to how the money is supposed to be used for the rest of the child's life. It's usually put in some sort of trust so that the child's bills will be taken care of for the rest of their life. At that point, when that's done, the case will end. Now, at our firm, we want to make sure that we remain in contact with the client to make sure that everything's going okay. There's issues that are going to come down the road. In these types of cases, there always is. We want to make sure that the banks involved, the structured settlement folks, are all doing their job and taking care of the family. So that's the nuts and bolts of a medical negligence lawsuit. If you found this helpful, you'll want to subscribe to the Shannon Law Group YouTube channel, and also like this video and let your friends know that these types of videos are available for educational purposes.